Hey everybody, I've got some incredible news to share with you, and it's fresh out of California. Once again, we are looking at a major legal victory that completely turns the tables on one of the state's long-standing gun laws. It's not every day that we see the tide shift in California of all places, but right now, that's exactly what's happening. This is one of those updates that I've been waiting for, and I know many of you have too, because the impact of this case doesn't just stop at California's border. What happened here has ripple effects across the entire country, and it's proof that the momentum is on our side. So let's break it down. For decades, California has had some of the strictest firearm laws in the nation. If you live there, you already know how much red tape stands between ordinary people and their right to carry. And if you don't live there, well, California has essentially been a brick wall. The state doesn't recognize carry permits from any other state, zero reciprocity whatsoever. That means the moment you cross that invisible line into California, your permit is worthless. You're effectively disarmed, even if you've gone through the full process in your home state. And on top of that, California flat out refused to let non-residents even apply for a permit. You could live right across the border, visit family, travel for work, whatever the case may be, and the state still shut the door in your face. No process, no paperwork, no shot at exercising your right to carry. Now, this is not a small thing. Think about it. Reciprocity is already common sense. If you have a driver's license in one state, you don't suddenly lose the ability to drive when you cross state lines. It's recognized everywhere. That's just logical. But when it comes to your Second Amendment rights, California has treated them like they simply disappear once you cross into their territory. That has been the reality for years, and it's been frustrating to watch people's rights get stripped away just because they're on the wrong side of the border. That's why this case is such a big deal. We're talking about Hoffman v. Bonta, a challenge spearheaded by the Firearms Policy Coalition. And if you follow Second Amendment battles, you already know FPC has been on the front lines of so many of these fights. Alongside FPC, there were individual plaintiffs like Christopher Hoffman, who represent the very people being directly shut out by California's law. This wasn't some abstract legal question. These were real people saying, look, the state is denying us our constitutional rights just because we don't live there. And that's not how the Constitution works. Now, if this sounds familiar, it's because there was a previous case, CRPA v. LASD. That one made a bit of headway for certain members of the California Rifle and Pistol Association, giving them a narrow pathway to apply for non-resident permits. But here's the catch: the hoops you had to jump through were ridiculous. Even California residents didn't have to go through that many steps. It was like the state was saying, fine, you can try, but we're going to make it nearly impossible. And that's exactly what they did, stacking on requirements, affidavits, extra paperwork, layer after layer, until the process became a wall of its own. Hoffman v. Bonta went right after that same barrier, but this time with FPC at the helm. The argument was straightforward. California's blanket ban on non-resident carry is unconstitutional, period. There's no legal justification for treating non-residents differently when it comes to a fundamental right. And let me tell you, this case has been on the radar for a while, building up piece by piece. Every step along the way, people were watching closely, waiting for that moment when the court would finally weigh in. And here's the best part: that moment has come. We're not just talking about a minor step forward. We're talking about a full-blown ruling that changes the game. The court didn't buy California's excuses, didn't let them create endless obstacles, and instead recognized what many of us already knew, that this law couldn't stand. That's why this update feels so big. It's not just another headline. It's confirmation that the tide really is turning, even in a state as hostile to the Second Amendment as California. So, right now what we're seeing is history in the making. The fight against California's non-resident carry ban has reached a point that nobody can ignore anymore. This is hot off the press, and it sets the stage for everything that comes next. The decision on July 1st was already a huge moment, because it set the foundation that California's outright ban was unconstitutional. That alone had gun owners across the country talking, since it was the type of ruling that people had been waiting to see for years. But almost immediately, the state showed it had no intention of making the process simple. Officials started drafting their own version of compliance, one that was packed with barriers designed to keep outsiders from successfully applying. They wanted to make sure that even though the court had recognized non-residents should have a path, that path would be so twisted and narrow it would discourage almost everyone from walking it. What the state proposed included requirements that went far beyond common sense. Non-residents would need to file in the county they planned to visit, sign legal affidavits about their intentions, and follow more than 5 pages of extra rules. These conditions were far stricter than those applied to California residents, creating an unequal system that violated the spirit of the court's July decision. To many, it looked like California was trying to win by losing, acting as though they accepted the ruling while quietly stacking the deck against anyone from outside. The Firearms Policy Coalition made it clear they were not going to accept that kind of compromise. They argued directly to the judge that such conditions kept the unconstitutional ban alive in another form. Their demand was simple and direct, a clean injunction that wiped the law off the books without carving out loopholes for the state. This became the central conflict in the weeks that followed, as lawyers for both sides debated what the court's order should look like. On August 21st, the fight reached its decisive point. The judge issued a permanent injunction that did exactly what FPC had asked for. The wording of the order left no doubt about its meaning. The Attorney General, along with every officer, agent, and employee acting under his authority, was permanently barred from enforcing Penal Code Sections 26150A3 and 26155A3 against non-resident applicants who were members of the Firearms Policy Coalition. The order was signed by Judge Cathy Ann Bencivengo, making it crystal clear that the state's attempt to impose extra burdens was not going to stand. For FPC members living outside California, this was the breakthrough moment. Instead of jumping through a maze of extra steps, they could apply just as a resident would. That meant filling out the same forms, meeting the same training standards, and going through the same county processes, nothing more, nothing less. It was an equal footing that had never existed before. In practical terms, it meant travelers and visitors who were willing to join FPC suddenly had access to legal protection that had been denied for decades. Reactions poured in quickly. Supporters of the Second Amendment saw the ruling as a long overdue recognition that rights should not stop at state lines. Many described it as a strike against California's habit of building two sets of rules, one for its own citizens and another for everyone else. Critics of the ruling, on the other hand, warned it would create challenges for law enforcement and public safety, repeating the same talking points used every time restrictions are rolled back. But the legal reality was simple. The court had spoken, and the state was permanently enjoined from enforcing its discriminatory ban. This does not mean the broader fight is finished. California still refuses to honor permits from other states, and the ruling applies specifically to members of the Firearms Policy Coalition rather than to every non-resident. Yet the symbolism of this win is undeniable. For the first time, the wall that kept outsiders completely disarmed has cracks in it, and those cracks were created by the court itself. That fact carries weight, and it signals that even in one of the toughest environments for gun rights, the Constitution is still powerful enough to push back. Even with this new victory, it is worth being clear about what the court actually granted. The permanent injunction does not mean constitutional carry has arrived in California, and it does not mean that every visitor with an out-of-state permit can suddenly carry. The scope is narrower, applying directly to members of the Firearms Policy Coalition. That distinction matters. If someone is not a member, the ruling does not automatically extend protection. Joining the organization is what allows non-residents to apply under the same rules as Californians. At first glance, that can feel limiting, but it also represents an opportunity. By becoming a member of FPC, individuals are directly supporting the group that brought this case forward, while at the same time unlocking access for themselves. It is a trade-off that combines practical benefit with ongoing support for the broader fight. Every new member strengthens the coalition's ability to continue challenging restrictive laws, not only in California, but in other states that watch closely. Another point that needs to be addressed is reciprocity. Across most of the country, concealed carry permits are treated much like driver's licenses recognized from one state to another. This approach makes life easier for travelers and reflects the idea that rights should not vanish once you cross a state border. California has resisted reciprocity entirely. Nothing in this injunction changes that larger stance. If someone holds a permit from Texas, Nevada, or Arizona, it still has no standing in California. What the court created was a pathway to apply within California itself, not an open door for permits issued elsewhere. For those considering an application, there are some realities to prepare for. Counties within California do not all operate in the same way. Some have streamlined processes, while others are swamped with backlogs that stretch for months. Costs can also climb depending on the jurisdiction. Los Angeles County is known for being overwhelmed with heavy demand and slow turnaround. By contrast, counties like Riverside often move faster, though even their applicants need patience. Doing thorough research beforehand is critical because choosing the right county can make a huge difference in both expense and timing. These practical hurdles should not overshadow the bigger fact that the door has finally opened. Before this ruling, non-residents had no true path to a permit, only obstacles designed to shut them out. Today, a legitimate route exists because a federal judge recognized that the Constitution still applies, even in California. That is a milestone worth celebrating. It proves that organized legal action pursued persistently can chip away at restrictions that once seemed untouchable. In the broader context, this case fits within a national pattern that has been building since the Supreme Court's Bruin decision in 2022. Courts across the country have been reassessing state and local laws under that standard, striking down those that fail to respect the text and history of the Second Amendment. Restrictions on magazines' waiting periods and carry rules have all been challenged successfully. Hoffman v. Bonta now joins that growing list of wins, sending a signal that even the most resistant states are not beyond the reach of constitutional review. The message here is not that the fight is finished, but that momentum is real. Each victory matters, even if it does not solve every problem at once. For members of FPC who plan to travel into California, the implications are immediate. There is finally a pathway to apply and carry legally. Taking advantage of that opportunity means doing the legwork, researching counties, preparing paperwork, budgeting for fees, but it is a step that was completely unavailable until this injunction. This is why so many people keep repeating that a win is a win. Even when limited, it represents progress. Each ruling that chips away at California's wall of restrictions brings us closer to a future where rights are fully respected. For now, enjoy this victory. It is recent, it is meaningful, and it proves again that persistence pays off. Thank you for watching. I truly appreciate your support. If you found this update helpful, make sure to subscribe, hit the like button, and stay tuned for more as these battles continue.